Hello, everyone. Thank you for joining our webinar today. Let's begin by going over the agenda. In a few moments, I will turn the program over to Jim McGrath from our New York City office. Jim is going to update us on the new paid prenatal leave requirements that were added to the New York City Earned Safe and Sick Time Act. Next up, we will have Kadeen Maitland from our Westchester office. Kadeen will be discussing a recent change to the New York State Office of the Medicaid Inspector General compliance program reviews. Jennifer Sin from our Albany office will then update the group on a legislative development involving retail to retail alcohol sales. And last but certainly not least, we will have Samantha Nice from our Long Island office. Samantha will be updating us on an interesting NLRB, National Labor Relations Board, administrative law judge decision that addresses when an employee's speech loses protection under the National Labor Relations Act. Okay, I will now turn the program over to Jim for his update. Jim?
Great. Thank you, Carrie. Although this is titled a New York City update, I'm really going to be speaking both about the New York State law and the New York City law, and with an emphasis on the differences between the two. Next slide, please, Kathy. So the New York City Department of Consumer and Worker Protection, the DCWP, that is the agency that coordinates and monitors compliance with the New York City Earned Safe and Sick Time Act, sometimes called ESTA. In any event, what the city is doing is amending its own Earned Safe and Sick Time rules to incorporate paid prenatal leave, which of course is now a state law requirement as well. So for you New York City employers, let me just remind you of what ESTA requires. Employers of 100 or more have to provide up to 56 hours of paid leave per year for personal or family illness, preventive care, or safety needs regarding things like domestic violence, stalking, or human trafficking. If the employer has 5 to 99 employees, then it's 40 hours of paid leave. If the employer has fewer than 5 employees and a net income over 1 million, it's 40 hours of paid leave. And if you have fewer than 5 employees and less than $1 million in net income, it's 40 hours of unpaid leave. So effective July 2nd, that's tomorrow, the city will incorporate these prenatal leave requirements that I'm going to go over with you into its ESTA requirements. Next slide, please, Kathy. So what ESTA, or what the DWCP is doing, is incorporating the state law into the ESTA, the city law, and there are some differences. But just as a reminder, New York State paid prenatal leave went into effect January 1. Private sector employers have to provide 20 hours of prenatal personal leave during any 52-week period. And that starts when the leave is to be taken. So it's a rolling 52-week period. What can you take leave for? Physical examinations, medical procedures, monitoring, testing, discussions with a healthcare provider as to health during a pregnancy, end of pregnancy care, and fertility treatment. Next slide. And the thing to note here is this is a separate and distinct benefit from other leave policies. This is 20 hours that stand alone that you have to provide to an employee automatically for those reasons. And this benefit accrues the day they walk in the door. So literally somebody can be there just a couple of days and say, I now need to take time off for prenatal care, and you have to provide that. You, the employer, must provide that. One thing to remember, it's only for the employee, not for the employee's spouse or partner. Next slide. So the ESTA, that's the Sick and Safe Time Act, it models or it incorporates the state law, same provisions, 20 hours of paid prenatal leave during any 52-week period for the same pregnancy health reasons listed in the state law. Next slide. There are differences. The differences we're going to go through. They're not as significant as you would think on first blush, with the exception of the requirement of a written policy. But we've identified four differences between the city law and the state law. The first is the record of use. That is the record you have to provide to employees regarding their use of prenatal leave. A written policy, that's the big difference. Under the city law, you must provide a written policy, reasonable documentation, and separate leave. I'll get into each of these four items. Next slide, Kathy. So the written record of use, when this came out, or actually as it's written, it says that an employer must provide the employee with a pay stub or pay statement that reflects their usage of prenatal leave. And in New York City, many of you are already complying with this with respect to the Safe and Sick Time Act. You're supposed to have a box in your pay stubs that reflects employees' usage of sick time and safe time. I don't know, frankly, why this requirement is there, in the sense that how many boxes can possibly fit on a pay stub, but that's what New York City says. Now, the good news is, though, in their FAQs, the frequently asked questions, New York City has said this information must be on a pay stub or other pay statement, meaning a weekly pay statement, or in separate written documentation. And that's actually just like the state law. So if you don't have it in a pay stub, you do have to give a weekly update as to the employee's usage of paid prenatal leave. Next slide, please. So as I said, there has to be a written policy, and this policy has to be provided at the time the employee is hired and within 14 days of any change to your paid prenatal leave policy. Next slide. Reasonable documentation. If you read these two bullet points, they sound like they're inconsistent or contradictory. First, employers may require reasonable written documentation that the use of paid prenatal leave for purposes authorized by the law. But then you read the next bullet point and it says you can't ask for documentation about the employee's condition using such leave. So what does that mean? It's going to become very much like an FMLA notice that just says a healthcare provider will certify that the employee is taking leave for purposes protected by or referenced in the paid prenatal leave law of either the state or city. You can't say to the employee, well, are you having fertility treatment? Are you having in vitro conversations? You obviously could not ask about end of pregnancy treatment or anything of the like. So you're entitled to ask for documentation that the individual is taking something for paid prenatal leave, but that's about it. Next slide. Separate leave. What this means is employees can't be forced to use or exhaust their other leave in lieu of paid prenatal leave. So you can't force them to use their vacation time or their sick time. The city rules come right out and say, though, that you're allowed to have an employee change their schedule to take prenatal leave time. But here's the kicker. It says if there is mutual consent between the employer and the employee, so you can work that out. In my opinion, that's not really inconsistent with the state law. If obviously under the state law, if you mutually agreed to that, that would be fine. But the city law does indicate there is this provision to work out an alternate schedule with respect to paid prenatal leave. Next slide. So our suggestions: you need to have a written policy. You need to have some method to inform your employees as to how much they have used and how much they have remaining. By the way, it's only for those taking the leave. So you would not have to tell everybody, for example, you have 500 employees, you wouldn't have to say to them, you have 20 hours of paid prenatal leave available to you. It's only those who indicate that they're going to be taking leave, and then you monitor it. The policy, of course, will say that everyone is entitled to take this sort of leave. So that is, in a nutshell, that's both the New York State paid prenatal leave and the differences that are now, as of tomorrow, effective in New York City. Let me turn it back to Karen.
Thanks, Jim. We had a couple questions in the chat, and I'm just wondering, we had a question a couple times, Jim, if you know the answer to this. Does the paid prenatal leave apply to part-time employees as well as full-time? And if so, is it a prorated 20 hours, or do part-time employees also get 20 hours of paid prenatal leave?
My understanding is that it applies to part-timers, and it is 20 hours. I will confirm that, and by the end of our little presentation here, I'll post the answer.
Thank you. Yeah, that's my understanding as well, Jim. But thank you for checking on that.
Sure.
Great. Okay, so next we have Kadeen to discuss the OBANK development. Kadeen, thank you for joining us today. I will turn it over to you.
Thank you so much for that, Carrie. I'm Kadeen. I'm an associate in the healthcare and long-term care practice group. So today I'll be giving a couple updates and a little bit of historical context regarding compliance programs. Next slide, please. So the New York State Office of the Medicaid Inspector General will be expanding its compliance reviews. So reviews typically ensure providers maintain effective compliance programs as required by Title 18, specifically Part 521. Next slide, please. So just a little bit of context before we actually get into the key update. So back in December of 2022, there was generally pivotal updates, and how that originated was from the Medicaid Redesign Team 2's recommendations. And it was constructed through a bunch of proposals from July 22, and then finalized with some minor adjustments. Next slide, please. So some of these key historical regulatory changes that came about in December of 2022 included an increased monetary threshold to $1 million for significant business operations. A self-disclosure program was adopted. Also introduced were standards for compliance documentation retention. There was an expansion of specific risk areas to be addressed by required providers. There was a reduction of compliance obligation parameters for vendors and contractors of required providers. Equally important, there was a requirement for compliance programs to include DRAW, which is Deficit Reduction Act training. So that includes adding into your compliance programs provisions on fraud, abuse, waste, and whistleblower statutes. Next slide, please. So future impact and guidance since 2022. So they had forecasted some things that would be developing since December of 2022 from the Office of Medicaid Inspector General, and those included new training modules, a more streamlined reporting process, special MMCO requirements, that's your Medicaid managed care organizations, and under that, including claim auditing thresholds were adjusted and noted. The standards for a compliance officer were specifically delineated, and then OMEG's compliance review process. Next slide, please. So the key update, so last week, June 26th, OMEG sent out a note that as of today, July 1st, 2025, reviews will now cover a 12-month period rather than the previous 90-day look back that OMEG had in place from summer 2023, when it began performing compliance reviews under the revamped standards of December 2022. So this change allows for a more comprehensive evaluation of provider compliance. However, this will not affect reviews currently being conducted by OMEG. Next slide, please. So the process is providers will receive a written notification from OMEG outlining the review period and the procedures. Then they will submit completed module plus documentation within 30 days. And then providers will be notified about the review results post-completion by OMEG. Next slide, please. So Bond has helped with many compliance program reviews or just compliance in general since 2023, since the updates have occurred. And if there's any assistance or any advice, you can definitely contact one of us regarding navigating the new requirements and making sure your program is in place. Next slide, please. Also, Bond has an ongoing partnership with the Office of Medicaid Inspector General. So quarterly for over a year now, we've been doing deeper dives with officials from OMEG in which we have webinars, presentations on compliance and operational integrity, and it allows for audience members to have their questions answered, as well as OMEG each quarter will have a specific topic that we are discussing. So please stay tuned for a date which will be released for this fall. Thank you so much.
Great. Thank you so much for the update. As KD mentioned, if you have any questions about OMEG compliance reviews, please feel free to reach out. Jen is up next to discuss retail to retail alcohol sales. Jen?
Great. Hi, thank you, everyone. I am Jennifer Sin, co-chair of our hospitality and tourism practice group. So thank you for having me back on to talk about one of my favorite topics, the sale and service of alcohol in New York. So today I'm going to give you just a very quick update on Senate Bill S409A, recently passed the Senate and the Assembly. And that bill will allow bars and restaurants in New York State to purchase limited amounts of wine and liquor directly from retail liquor stores. So previously, those establishments were legally required to buy alcohol exclusively through licensed wholesalers. Even when they just needed like a few bottles to, replenish some fast-moving inventory or had an unexpected shortage and their next delivery from their wholesaler isn't due, they weren't allowed to buy from the local liquor store. So this bill would allow that. It introduces a weekly cap of up to 6 bottles per licensee per week that the business can purchase from a liquor store to address those sorts of short-term shortages and outages. So the bill hasn't been signed by the governor yet, however. Governor actually hasn't publicly stated her position on the bill. There hasn't been that much opposition or controversy surrounding it, although at least one major alcohol producer did issue a memorandum in opposition. But given that the bill just legalizes a workaround that many restaurants were already using to buy small amounts of wine or liquor from retail stores in emergencies, it's expected that the governor will sign it, but of course, until she does, it's not really a done deal. So we'll be monitoring that. If it does get signed, what will that mean for the hospitality industry? Restaurants and bars would be able to respond more quickly to that sort of unexpected demand, that situation where they run out of a particular wine or a particular alcohol that they needed on a quick basis. So hopefully that would avoid some revenue loss from running out of products. And of course, retail pricing is higher than wholesale. But this new option would allow them to hopefully avoid some of that customer dissatisfaction when they run out of things. In fact, the bill really is just acknowledging a workaround that many hospitality businesses were already using. So it would bring them into compliance, which would reduce that risk of fines from the liquor authority. And because we have that 6 bottle per week limit, it's really not expected to replace the role of wholesalers, but just to supplement it. We think it'll be especially useful for those sorts of smaller establishments that maybe have limited storage or maybe have more unpredictable turnover in product. So in short, we expect that the bill will ease this one particular issue for New York's hospitality industry, but not significantly disrupt that existing alcohol distribution system. But we will be monitoring it to see if that is signed and where that goes. So that's it for me.
Thank you. We appreciate the update. Next, we will have Samantha to talk about the NLRB ALJ decision. Samantha?
Hi, everyone. As Carrie just mentioned, I'm Sam Nice. Today, I will be presenting about an interesting recent administrative law judge decision involving a reporter at the Washington Post who was fired for making derogatory social media posts. So you may have actually heard about this case. It was major news back in 2022 when it all started, with major news outlets like the New York Times publishing stories about it. But essentially in 2022, the Washington Baltimore News Guild filed unfair labor practice charges against the Washington Post, claiming that it had illegally fired its former employee, Felicia Sonmez, after she criticized the Post in a series of tweets. And on June 16th, 2025, the NLRB's chief ALJ, Robert Gianassi, issued a decision finding that the Post's firing of Sonmez was lawful. So I figured I'd start with the facts as they're laid out in that decision. So Sonmez was a breaking news reporter for the Post, and the Post encouraged its reporters to use social media to share stories and obtain new ideas for their own stories. And Sonmez did just that, particularly on Twitter, which is now known as X. She had approximately 100,000 followers on Twitter, and hundreds of them were her fellow Post employees. So her posts were clearly reaching a large audience. And on Friday, June 3rd, 2022, at 12:30 p.m., Sonmez was looking through Twitter and she saw a retweet that a fellow Post reporter, David Weigel, posted. And it read, "Every girl is bi, you just have to figure out if it's polar or sexual." And Sonmez was not happy about this retweet whatsoever. She immediately screenshotted it and sent it as a message in a group chat with about 500 Post reporters in it, captioning it, "What is this?" And several employees agreed with her that this retweet was problematic. Soon after, a higher up at the Post, Matea Gold, sent a message to everyone stating that she wanted to assure them that the Post is committed to maintaining a respectful workplace for everyone, and they didn't tolerate this type of language. And also within minutes of this retweet, Gold sent messages to a bunch of other people at the Post, including Weigel's supervisor, and they ultimately decided that they were going to order him to remove the retweet and to issue a public apology, which he had done really quickly. By 1 o'clock, he said that he would make a public apology and that he'd already unretweeted the Post 15 minutes prior, and the Post also suspended him for 30 days. But before this apology happened, Sonmez had gone on Twitter herself. She sent a public tweet containing Weigel's retweet in it, and she wrote, "Fantastic to work at a news outlet where retweets like this are allowed." She also retweeted a post that read, "It is totally normal that a Washington Post political reporter retweets this misogynistic crap. Totally, totally." Sonmez then proceeded to spend 5 days sending out constant public tweets on the issue to her 100,000 followers, criticizing the Post's handling of the situation, claiming that the Post allowed this sexist behavior, and suggesting the Post was responsible for online harassment she was receiving in response to her tweets about the matter. She literally posted 100 times, so it's far too much to delve into. But on top of these tweets, the Post editors received numerous complaints from newsroom staff about Sonmez's ongoing Twitter activity, which they described as creating distress in the workplace. And ultimately, the Post discharged Sonmez on June 9th, 2022. On June 15th, the guild protested the discharge by filing a grievance over the discharge and initiating the first step of the grievance procedure set forth in their CBA. The parties held one meeting on the grievance, but there was no resolution, and the guild later decided not to take this case to arbitration. So now let's get to the ALJ's analysis of whether Sonmez's speech was protected under the National Labor Relations Act. So an employee violates Section 8A1 of the National Labor Relations Act if it discharges an employee because that employee engaged in protected concerted activity within the meaning of the act. And the act protects employee activity that is concerted and addressed to mutual aid and protection. Concerted activity is broadly defined as an activity that is engaged with or on the authority of other employees. And the phrase that I used before, mutual aid and protection, focuses on whether the employees are seeking to improve their terms and conditions of employment. However, there are limitations on protected concerted conduct, and in some situations, otherwise protected communications lose the protection of the act. Section 7 protections may extend to communications with third parties or the public through channels outside the immediate employer-employee relationship. In such cases, that an NLRB applies the two-prong encore test to determine whether Section 7 protections apply. So the first prong of this test is whether the communication is related to an ongoing labor dispute between employees and employers. And the second prong is pretty interesting. It's whether the communication is so disloyal, reckless, or maliciously untrue as to lose protections of the act. And here, the ALJ applied this encore test and concluded that Sonmez's Twitter activity failed the first prong because it wasn't related to a labor dispute. And it didn't address workplace conditions. Much of her tweeting appeared to be her own personal commentary on sexism and her general, own experiences. The judge noted that Sonmez herself had explained that she used Twitter as a platform to help others feel less alone and seen, and heard regarding online misogyny directed at female journalists. And even assuming that her tweets could be viewed as protected activity in support of a labor dispute, it still would have been unprotected under the second prong because it was disloyal, reckless, and disparaged the employer's reputation. Weigel had taken down his retweet after only 15 to 30 minutes after he apologized, but Sonmez kept retweeting it and keeping it alive, amplifying the very thing she was condemning. She sent tweets falsely stating the post was doing nothing about the retweet when she knew that wasn't true, and she repeatedly tweeted that the post was responsible for abusive responses she was receiving from people online. So accordingly, the ALJ found that the general counsel did not prove by a preponderance that the post violated 8A1 of the NLRA for discharging her because of protected activity and dismissed the complaint in its entirety. As for the implications of this decision, I just wanted to mention that this is only an ALJ decision and it can be appealed to the National Labor Relations Board. An ALJ decision is not binding legal precedent in other cases unless it has been adopted by the board on review of exceptions. So these judges function much like trial court judges hearing a case without a jury. If no exceptions are filed, the ALJ's order will become the order of the board. So we'll have to stay tuned and see what happens here. But that's all I have. Thank you.
Thank you so much, Sam. We appreciate that, that update and discussing that decision. And thank you everyone for tuning into our webinar today. We have the contact information for all of today's presenters on this screen. As always, please feel free to contact any of the presenters or myself with any questions. Gabe will be hosting the webinar next week on July 8th. Please join him if you are able to do so. Enjoy the rest of your day. Thank you.